Hey everybody, John Skiba here, and in this video I'm going to do something that a number of people have requested even just recently, and that is I'm posting the entire video of the oral argument I did, a case that I had in the Arizona Court of Appeals against the junk debt buyer Midland Funding. Now this goes back a couple of years ago, and previously on the YouTube channel I actually posted my portion of the oral argument, but I get this, a lot of people are saying, hey, I want to hear what the Midland Funding's argument was so that I can kind of understand what this whole argument is regarding the business records of junk debt buyers. So what's going to follow here is a recording that the Court of Appeals does of the attorney for Midland Funding, their oral argument, and then my oral argument before this three-judge panel, which is the Arizona Court of Appeals. And specifically what we're going to be arguing is what's called the business records exception to the hearsay doctrine, which I know is a mouthful. But what we're doing is essentially we're saying, my argument was, look, these documents should not come into court because the witness for Midland Funding has not laid proper foundation. They haven't authenticated these documents and they haven't followed the rules of evidence. You're going to hear us talk about Rule of Evidence 803, subsection 6, throughout this argument. You may want to get a copy of that and take a look at it before you watch the video, just because that'll help you to understand exactly what it is that we're arguing about. So go ahead and, it's a little lengthy, it's about a half an hour long, but it does lay out the arguments in detail on both sides. You're going to hear what Midland Funding's position is, you're going to hear what my position is. My position's right. I actually won this appeal. That's a spoiler alert. We won the appeal here. And won the case for our client, because this is a case we had won at trial. We were able to get they appealed it, Midland Funding appealed it, and we were able to prevail in the appeal and have the ruling stand, so the case got dismissed. So take a look at it. I'd love to hear kind of your feedback and your comments, any ideas or questions you may have. Go ahead and put them down in the comments. I do read those. If you follow the channel, you'll see that I do respond to things quite a bit. But go ahead and take a look at it. This is my oral argument and Midland Funding's oral argument before the Arizona Court of Appeals.
All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Erica, do you have the sign-in sheet? The court now calls case number CV 2013-4551. This is Midland Funding LLC versus Lisette Van Slyke. This is the time set for oral argument. Good morning, counsel. Let me advise you, you both have 20 minutes to present your argument. Counsel for the appellant, you can reserve some time for any rebuttal. Just let us know when you first get up here. The proceedings are being recorded, and by that I mean they're being audio and video recorded, and those will be these arguments will be uploaded to our website so people can view them within a couple days of today's argument. Keep in mind we have read your briefs, we've looked at the case, we've discussed the case, so we're very familiar with the facts. And you can keep track of your time on the podium in front of you. There's a clock on the podium in front of you. So, counsel for the appellant, it is Mr. Flaming Bushman?
That's correct.
Okay. Go ahead, sir.
Thanks, John. And I would like to reserve time for rebuttal. Thank you.
How much time?
Whatever I have left. I don't anticipate this taking too long. It's a single issue case. Rhett Fleming Bushman, if it pleases the court, for the plaintiff and appellant Midland Funding. As the court has reviewed the trial record, they'll know that a trial was held, and at trial a certain piece of evidence marked as Exhibit 3, which was Chase credit card statements, was not admitted, and that is the basis for this appeal. At trial, the judge stated, I don't think you can meet the foundational requirements for these documents without something from somebody from Chase who knows how these are generated. He did conditionally admit the statements after plaintiff's counsel pointed the court to a reference in State v. Parker, which purportedly allowed business records of one entity that are incorporated into the proponent's business records to be admitted without any sort of foundational requirements from the creating entity.
Well, let me ask you about that, because I'm not sure that's exactly right in Parker, because in Parker, Ms. Ward, the custodian, was testifying about her own employer's Capital One records, wasn't she?
Yes, the person who was testifying testified to Capital One's records, but the basis for the challenge on appeal on that issue was that the Capital One person had no knowledge of the underlying transactions and how those were given to Capital One. In essence, they called it a hearsay within hearsay.
But she did. She was testifying about her employer's own records, and according to the Arizona Supreme Court, she further testified about, quote, how merchants and other parties transmitted the information used to create the records. And to me, that's the big distinction between Parker and your case, because the single witness in this case didn't provide any comparable testimony about how the Chase charges might have, either based on industry practice or specifically, come about.
Yes, I agree that that particular piece is, the way you're reading that is correct. However, the court went on to quote other cases, specifically it said, see, for example, United States v. Adafahinti, listing cases that permit business records of one entity to be admitted as a business record of another entity if the latter entity relies on those records and keeps them in the ordinary course of business. Meaning that what the court was saying is that, because Parker had argued there was a double hearsay problem because Ward, who was the person who testified, did not know who transmitted the information into Capital One's database. Meaning Ward did not know who made the charges on that. And in fact, the charges purportedly were made by the defendant fraudulently after taking the murder victim's credit cards.
In this case, when the trial court said, no, I don't think the Business Records Foundation has been laid here sufficiently, was there an alternative argument asserted by Midland of one of the catch-all exceptions to the hearsay rule for documents that might be deemed reliable?
No, and in fact, the plaintiff's counsel essentially once went to admit the documents. The judge didn't say that these were there was no proper foundation by the person who was admitting them. He said that you need something from someone at Chase. So essentially saying that the requirement of the rule is that the originating or producing, creating entity needs to be there to testify in some form.
That does seem to be the literal application of the hearsay exception in the rules of evidence.
It does, Your Honor. It literally does. However, as the court has stated in State v. Parker, that there's no requirement for the records have been prepared by the entity that has custody of them, and that trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. So while the rule itself states that, and when State v. Parker quotes United States v. Adafahinti, United States v. Adafahinti describes what's required for this personal knowledge and when records are made. And in that case, which isn't, it's from the Federal Circuit, but quoted here by State v. Parker, in that case, the records, the court said that the records were made when they were incorporated into the bank's records. Meaning these records that were put into the case in United States v. Adafahinti were in no means the bank's records. These were records that were submitted by mortgage brokers. So they weren't their own records. There were no mortgage broker testimony. It was only the bank's testimony. And so the court said when they say made, it means incorporated into the records. And the knowledge requirement under this rule was the knowledge of the incorporating entities, the bank in that case, their filing system, and their use of the records. And they were admitted because they were incorporated into the records and relied on it. And
I mean, that's a huge, I think I understand what you're saying, and I think I need to look at that federal case you're citing further, and I will. But you're suggesting here that State v. Parker has created a huge amendment, really, to the written rule of evidence setting forth this business records exception.
Yes, I am. And in fact, there's no further cases, published opinions, but this court has issued several memoranda of opinion that support that. Since
Let me
State
go
v.
back
Parker.
to the statement that you rely on so heavily in Parker, because I read it differently than you're urging. Trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. I read that as the third party submitted the information as part of the third party's ordinary course of business. And the issue that it seems clear Judge Warner was focused on here was that Ms. Johnson could say nothing about the Chase records other than, we only buy from reputable companies, so we rely on it. And it seems clear both from his initial ruling and then his clarification in the motion for reconsideration denial that that was what he was stuck on, which seems to me consistent with Parker. Otherwise, you're essentially asking us to adopt a rule that would gut the business records rule, that anytime somebody has a third-party record in its own business records, that other record is a business record, which I don't think is consistent with our own jurisprudence.
And let me dovetail on that a little bit. I mean, what's to prevent this adopted business record exception from applying to some company that has a bad debt and turns it over to an attorney to collect on the debt, and then the attorney, having a paralegal in the office, provide some affidavit that we rely on these records we receive from our clients as business records to prove the nature of the debt. I mean, there's all kinds of situations where a company turns over records to somebody else to collect, and that third party, be it an attorney or a collection agency or something like that, may have a very good understanding of how those records were put together, how they were made, or not. That doesn't have to be some kind of showing from the party that is adopting those business records that, yes, we rely on these records and we have some knowledge about how this company put those records together. We don't have a witness who personally saw them compile these records, but we know how they do it. We have some information from Chase, for example. Don't you have to have some link there, or are you just going to have people bootstrapping bulk records into anybody who can say, we use these records all the time?
Yeah, understood.
That's the concern, I think, that the trial court would have and that any court would have.
Of course. And Adefahintze, when they're quoting, they talk about trustworthiness and reliability. State v. Parker talks about trustworthiness and reliability. And in this case, State v. Parker, they argue that the trustworthiness and reliability of those incorporated records stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. Midland Funding, LLC, is a debt collector, and they're a debt buyer. They do two things. They buy debt, which by its very nature means that they are buying third-party records. They're buying someone else's defaulted account, and then they're collecting on those. They need a way to verify that. And federal law requires, under the Fair Debt Collection Practices Act, that they send out a dunning letter that says because essentially who's going to have the information that these are reliable, that these records get there, is first the original creditor. And the testimony in this case, if you look at the testimony, Midland's witness testified that Midland regularly buys from Chase, meaning they have a relationship with the bank that would establish that they have a standing business relationship where that kind of trustworthiness and reliability can be taken care of. They incorporate those third-party records, the Chase records, into their records. Chase regularly submits those records to Midland Funding as a part of their business, of the regular business of selling debts to Midland.
But why wasn't this handled the same way as the other Midland case that Judge Warner referenced, where there was simply an affidavit from Chase saying, these are our credit card statements, and that was sufficient to qualify. Here, there wasn't anything like that, was there?
And if you read the transcript, and this is a bit of a quirk, and actually why this case came up on appeal, the attorney for the counsel for Midland Funding.
Off the affidavit.
Exactly.
Well, and that's the problem here.
I understand that, but State v. Parker indicates that third-party records are admissible.
Well,
And it quotes this Adefahinty case, and in Adefahinty, my apologies. Mr. Gemmell, did you have a question?
yeah, I just wanted to build on what you and Judge Downey have been talking about here. I believe I see exactly what you're...
And Judge Gould, too.
Well, yes, I didn't mean to...
Talking about it.
I meant to include Judge Gould, of course.
Thank you.
I'm looking at paragraph 33 of the Parker case now, and I think I see exactly what you're relying on and arguing. It says courts regularly admit business records even when the testifying witness did not assemble the complete record. And then later in the paragraph it says, citing the Adefahinty, I'm not sure how to say that case, trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. And our Supreme Court cites the Adefahinty as listing cases that permit business records of one entity to be admitted as a business record of another if the latter relies and keeps them in the ordinary course of business. But then the court says the trial court did not abuse its discretion in admitting this evidence. This almost sounds like this may be one of those areas where if the trial court admits them, we're probably going to say no abuse of discretion, but if the trial court excludes them, maybe it's no abuse of discretion in that case as well. This seems to be sort of a middle ground. What can you help me with there? In other words, in this case, you have the uphill burden of convincing us there's an abuse of discretion. And in Parker, they didn't say these are always admissible. They in essence said they said the trial court did not abuse its discretion in this instance.
Yes, but the case in Adefahinty did not. You're welcome to, Your Honor.
Sorry.
The case did not say that third-party records were not admissible.
It did not say that either. I agree.
So legally, if there's legal error and it substantially affects the case, as here, that evidence didn't get in and that was the basis for the judge's decision, then that can be overturned. So is there a middle ground here? Yes. If the judge below says, look, I understand that third-party records are admissible, that's part of the rule. And if you look at the Adefahinty case, it cites other cases from other jurisdictions where certificates of title created by other parties are held by a car dealership. Customers' financial statements that they create are held by a bank, entered by the bank in the record as their own evidence. Freight bills drafted by one party, incorporated into the records of the receiving party, were admitted by the and offered by the receiving company were done. A toll receipt offered by the company that received it, not the company that created, without testimony from others. And there's plenty of federal evidence to back this up. And as far as the judge's view that this is not the case, that third-party records are simply not admissible. This is the judgment he was making. He started with that. He said, you need something from someone at Chase. It's like there's no way under current rules that third-party records are admissible without that. That was his decision.
That wasn't his ultimate decision. I mean, he did say that at one point, but in his later ruling, he specifically said he wasn't ruling that testimony at trial by a Chase representative was necessary, but only that the foundation Johnson had offered was insufficient. And then in ruling on the reconsideration, it distinguished, and you and I started to get into this, the attorney, and I don't know what the affidavit was that the attorney tore off during trial, but the fact of the matter is this case doesn't have an affidavit from Chase attesting to the authenticity of the credit card statements. And so it seems to me if you read Judge Warner's ultimate ruling and then his ruling on the motion for reconsideration, he in no sense is saying somebody from Chase had to be here.
Respectfully, I disagree. Essentially what he started with was you need something from someone at Chase. And then he said, I'm not saying that person from Chase would need to testify to be here live,
Sounds like he's saying you need an affidavit.
Yeah, because
But you need something.
He says here, no affidavit was admitted, so the only foundational evidence for the Chase credit card statements came from a witness whose only knowledge about them was that they were in Midland's file and Midland relies on them. So, to be fair to him, that's what he said.
Yes, and to back that up, in the State v. Parker, right afterwards, quoting United States v. Advahinti, it says, business records of one entity admitted as business records of another entity if the latter relies on those records and keeps them in the ordinary course of business. Meaning if those records are incorporated, they're in Midland's record, and they're relied on, and the judge says they were, and the judge went in and qualified the witness to say, yes, this witness is qualified to admit business records for Midland. He's basically saying these records are not Midland's business records. You need something from the other entity because it's their business records, not Midland's.
Do we have anything in the record about why the trial attorney ripped off the affidavit?
There's nothing in the record, but I do know the attorney.
No, thank you.
So as far as it goes, the case quoted United States v. Advahinti, there's other cases, especially the other premier case, seminal case on this particular issue is Airline Forwarders, Inc. v. U.S., which comes out of the Federal Circuit 1999 decision, basically said the same thing, that business records of one entity are admissible as business records of a second entity if they incorporate them and if there's other indicia of reliability, which is a simple test. But in that case, they said, yes, there's indicia of reliability because the service member, and to give you, I don't know if you have background on the case, I have 2 minutes left, but I'll try and hit it. The business records that were admitted in that case were business records, not really business records, but third-party appraisals of damage reports, which service members included with their report to the government when they asked for reimbursement for damaged furniture when they moved. And the plaintiffs in that case, which was Airline Forwarders, asked for, they sued based on set-offs, saying, hey, these amounts were set off, but there's no basis for them. And the only evidence that got in was these third-party appraisals, and in dissent, the dissenting judge indicates what these actually were. They're just various slips of paper with unidentified persons' estimates of cost. They didn't even know who created these appraisals. And in fact, the bank itself or the witnesses said for the government testified, and it was shown that they didn't know who prepared the documents, whether they were prepared contemporaneously with the events reported, or whether they were prepared in the ordinary course of business, or whether it was a regular practice of the business. But those records were still admitted. In Advahinti, the records that were admitted were fraudulent bank records that were brought into the bank, and the testifying witness had no idea how those records were originally generated. He only knew that there were dates on them, the names, and he knew that they were in their records. That was sufficient to get those in there. And Judge Downey, the dissent on that Airline Forwarders case, basically goes into what you're talking about, this need for something extra to rewrite the rules of evidence. But the case itself, the majority opinion, states these records were admissible, even though it's an appraisal incorporated into a service member's record, incorporated into the U.S. government records, and then submitted to court as the government records, with no references from the service member, no references from the appraisal company. So based on the federal precedent, what we're saying here today, that the third-party records of one company admissible into the third-party records of another, is what the federal law sets in most of our jurisdictions, including the Ninth Circuit. And in addition to that, the State v. Parker says the same thing, quoting Advahinti and saying, this is the example that we're setting. This is the examples you can look at to say this is how this rule comes out, because there's not much there.
Right. Thank you, counsel. All right. Is it Mr. Skiba?
Skiba, correct, Your Honor.
All right. Your argument?
Good morning, Your Honors. May it please the Court. John Skiba appearing on behalf of Lizette Venslake. Your Honors, the issue here with the underlying court, with Judge Warner, this is really a matter of reliability. How reliable are these statements that Midland Funding submitted, the Chase Bank statements. Now, Chase would have the court reduce the rule down to really two prongs. Basically, if they have possession of the documents and they have someone, not even someone from Midland Funding, as was in this case, someone state that the documents were relied on, that they are per se reliable. And if we take that out to its natural progression, I mean, the fact that they're stating that they're relying on these documents, to which their witness testified they had no background knowledge as to how Chase Bank kept and maintained its records. They had no information how the documents were even transferred from Chase Bank over to Midland Funding. That doesn't speak to the reliability of the Chase Bank documents. I mean, frankly, it speaks to the negligence of Midland Funding in relying upon them, to rely upon documents to which you have no underlying knowledge.
Counsel, I understand your argument, but I've read some of these federal cases, and there's some pretty broad language in those federal cases. I know that that's not binding precedent on us. What would you say about that?
I would say that almost without exception in the federal cases, there is this third prong, this indicia of reliability. There has to be something else. There has to be some testimony or something that gives the court some comfort that what they're receiving is reliable and accurate. And we saw that in State versus Parker. Judge Downey pointed out that the basis that the court made its ruling and found it reliable, they found that the Capital One employee who was testifying about Capital One documents was able to, testify that Capital One regularly made these documents. She was able to describe the transmission process from the vendors, and she was able to testify that these were normal business records of Capital One. That's something that we didn't have here. We had an employee from Midland Credit Management, Inc., a non-party, trying to testify on behalf of the plaintiff, Midland Funding, LLC, for documents that were created by Chase Bank. So there was this comfort that the Supreme Court could get in the Parker case in that they had the person there who was creating the records. And I'm not arguing that it has to be the specific person in every instance who created the document, but clearly they were influenced by the fact that they had someone there who was at least familiar with the underlying processes, which we didn't have here.
So what's a average trial judge to do? They get hundreds of these motions for default judgments. They don't have the benefit of the case going to trial and having a live witness, and they've got affidavits attached from Midland. Midland does a lot of collection work throughout the state. What does the trial court need to have in an affidavit where it can admit and accept those credit card records? Usually it's just a statement or two that's got, the past due account. Usually there isn't even the original contract that's attached. It's just the statement or a few statements. And these are records from Chase or some credit card company, a lot of them. They've been turned over to a third-party collection agency like Midland. What does a trial judge need to see in that affidavit so that she can believe that the documents are authenticated and admissible under the business record exception?
Your Honor, we need to see an affidavit, that at a minimum meets the requirements of Rule 8036. That goes through those specific requirements and has the documents attached stating that at least reviewed those. The problem that we're getting is we often get...
From the current institution that's the party, or from the prior institution where they were originally created?
From the original creditor. Because that's where I think the reliability issue comes into play. We have a case like this one where you have a witness who frankly knew nothing of the original creditor's business practices and frankly even conceded she hadn't even reviewed these documents prior to trial and giving her testimony.
Did she testify that Midland keeps these records in the ordinary course of its business and relies on them?
Well, and Judge Warner addressed that. In his ruling, he stated, she had, in his words, she had parroted the magic words of Rule 8036, but his finding was that there was nothing to support that. She had conceded time and again on questioning from myself, from the court, and even from her own counsel as to her knowledge of how Chase Bank keeps and maintains its records, and she didn't have any information or any answers. So the mere fact that she had stated that, the court said wasn't persuasive. There had to be some kind of substance behind it.
If you'll allow me another question here, what about these statements in paragraph 33 of Parker where our state Supreme Court said trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. and then it cites the Adafahente case and describes it as listing cases that permit business records of one entity to be admitted as a business record of another entity if the latter entity relies on the records and keeps them in the ordinary course of business. That certainly does not seem to require something in this case from Chase.
I think that Your Honor is quoting from paragraph 33 of that decision. I don't think we can read paragraph 33 and not review paragraph 31 as well,
right.
where the court specifically said, the last sentence of paragraph 31, these facts qualify the entries in Ward's report as business records. So the court's saying, and if we look at the beginning of paragraph 33, it seems the issue raised was, do we have to have the actual person who's created these documents, who was involved in the preparation of them? The court's saying, no, we don't. The courts regularly will admit documents, but there has to be some underlying basis and understanding of the underlying processes as far as how they're put together. And that makes sense because, as Judge Downey pointed out, if the court was to adopt what Midland Funding is proposing today, it effectively guts Rule 8036, and it really has no meaning. If the only thing that's required is possession of a document and saying that you're relying upon it, and then it comes into the court, one could see, as the court has pointed out, that the problems that could pose in many different areas.
I agree that it would gut the written rule of evidence for the business records exception, but isn't that what our Supreme Court has done in Parker?
Well, and let me weigh in here, because, I don't read that language in Parker the same way. I'm interested in your take on it, because trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. That means that Chase submitted as part of Chase's ordinary course of business. And as I read Judge Warner's ruling, that's the missing link here. There is nothing to show that Chase submitted any of this as part of its ordinary course of business. That's how I read Parker. I don't know that there's any other reading of that sentence.
Correct. There is nothing that Chase has provided, and when the witness for Midland Credit Management was asked that very question, she had no guidance either. She had no information as far as how the documentation was transferred from Chase Bank to Midland Funding.
And that's what gives it indicia of reliability, such that, hypothetically speaking, if there had been an affidavit from a Chase custodian of records saying these are Ms. Van Slyke's credit card records, we created them in the ordinary course of business, we've sold this account to Midland, doesn't even have to say all of that, but something to show that Chase has created and submitted these records as part of its ordinary course of business. That's what I read Parker as requiring.
And I would be in agreement with that, because otherwise simple possession satisfies the rule, right, which is problematic. And it's interesting because the way that this rule is applied in this case, we've actually reduced the bar as compared to what Chase would have to testify to if Chase were sitting in that courtroom testifying about its own documents. It would be held to the standards of Rule 8036. But for some reason, we're saying that the bar should be lowered dramatically as to a company, a third-party debt buyer. Particularly, we have a witness who's two companies removed from Midland Credit Management, Inc., testifying on behalf of Midland Funding, LLC. And so, again, Your Honors,
Would it be sufficient if the custodian from Midland included in her affidavit that she was familiar with how Chase keeps its records, how it compiles its records, and is aware that those records conform with, government standards, whatever applicable standards are, and also that she, on behalf of Midland, regularly receives those records and they incorporate those records from Chase in their business records? Would that be a sufficient link?
I think that that's going in the right direction, because I think that's what happened in Parker. Ms. Ward was able to testify about those underlying steps as far as how the vendor's documentation came to Capital One, and then how she compiled those documents and created her own record.
So you would concede perhaps you wouldn't need a separate affidavit from Chase as long as the person in Midland, for example, the third party, had a familiarity with how those records were kept and could establish a foundation for how she was aware those records were kept at Chase or whatever the company was you're receiving the records from?
If the witness is able to provide some kind of foundation as to how the documents were created, that they at least address the elements of 8036. If they're merely being able to testify as to essentially what filing cabinet this is stored at Midland Funding. I don't see how that gets over the issue of reliability.
Why wouldn't it be just as easy for a company like Chase when it sends these records out, and counsel, I'm sort of throwing this in your direction as well, to, when they send the records out to Midland, include an affidavit from a custodian of records saying these are our business records that we're submitting to you? Wouldn't that be a pretty easy thing to do?
One would assume that would be easy, and one would think it would be equally as easy. These witnesses are routinely granted telephonic appearances in the court. Why can't a Chase witness call in on the telephone as well to give some comfort as to the reliability of the document? Because what this does, as these are admitted, it effectively eliminates any effective cross-examination by the defendants. Because we have a witness who has been allowed to lay foundation for documents they have no understanding of, and yet it puts us in a position where when we ask that witness questions, they don't know, but the document has already been admitted. It also deprives the court of any rational basis on which they can base the trustworthiness of the document or the reliability of the document if we don't have additional information other than, yes, we have the document and we've relied upon it. So, based upon that, Your Honors, in conclusion, essentially and the court's brought up great questions as far as why don't certain things happen. And I think it's because Midland Funding would like the rules of the court essentially to adopt to its business practices.
I don't think that's true, counsel. I think they're confused. I think they're getting a lot of different direction from federal courts, different judges. They really just need to know, what do we need to do? And I think in fairness to them, it is a little confusing to them. So I guess I'd disagree with your position a little bit there. I understand what you're saying, but...
My main point is we need some kind of indicia of reliability for these documents. And this case is a glaring example of how little the lower courts get. We get witnesses who really don't know much about anything related to the underlying process.
I think that applies to every case I ever sat on as a trial judge.
Okay.
So.
All right. But I don't have anything further, and I thank you, Your Honors.
Anything, counsel? No. All right. That's a joke for the record. That's not true. All right. Thank you, counsel. We'll take this matter under advisement, and we'll issue a written decision in due course. Court's in recess.
All right, I hope that was helpful and hope that you somewhat enjoyed that. If you're into legal stuff, it's never quite as exciting as it is on TV. It's actually quite a bit less exciting. It's pretty dry. But it's interesting to me, as someone who deals in this all the time, the different arguments and the ideas that the judges are putting forth. And as I said in the intro to this, we actually won this appeal. The case we had won at the trial level. At trial, the court had said that Midland hadn't proven their case, so they entered judgment in favor of my client, dismissed the case, actually awarded us our legal fees. Midland Funding appealed it, and the court upheld the lower court's ruling. So we won. My client won this appeal. Something that's interesting with appeals that a lot of people don't realize, you can see here we had submitted written briefs and then oral argument. But it wasn't something where the Court of Appeals retries the case. And something that I believe played to our benefit in this is those three judges, what they were looking to see is if Judge Warner, who was the judge who did the trial, they're looking to see if he abused his discretion. So they aren't really saying that my position was 100% right. What they are saying is that we don't think that what the judge did down at the trial court level, that it was so out of bounds that we need to overturn it. So you can kind of take that for what it's worth. It's a victory, but it's not something that had a huge ripple effect through all the junk debt buyer cases in Arizona, just because of that very reason, that they said the judge did not abuse his discretion in the way that he ruled, and so he upheld our ruling. So it was great for my client. We got the case thrown out, and I have used this in other cases going forward, and I think it has provided some benefit, but I was hoping for something that would change the landscape, and unfortunately, this wasn't the case. Appreciate you watching. If you haven't yet, please go ahead and subscribe to the channel. Check off on that little bell. That way you'll be notified each and every week when I put out a new video that'll help you with your serious debt problem. We'll catch you next time.